there are various strikeouts sought in the replying affidavit of Professor London. The first one is paragraph 46. It should be, it says there 48. It in fact is an error. It should be paragraph 46 at 2614. The words that were sought to be struck out are the words which they simplistically understood to derive from a simple absence of meaningful consultation with the First Nations people. It seems to me that although that's a jibe put in reply for the first time, it's really no more than that. Although if they wanted to take that, make that kind of allegation, it should have been in the founding papers. I'm going to move swiftly on from that. It doesn't seem to me to be particularly consequential. Paragraphs 52.1 to 52.6 at 2615. That is a section seeking to undermine the AFMAS report, and for the reasons I've already indicated, that was available to the applicants, and if it was their intention to attack the report in various ways, and whether it fulfilled its purpose, that was part of an attack that ought to have been made in the founding papers, and to the extent that attack was made in the founding papers, this kind of evidence should have been put up to enable Mr. Orenser and the first respondent to deal with it. Attempts to discredit the AFMAS report with reference to obligations Mr. Orenser allegedly had is material that should have been dealt with in the founding papers. Paragraphs 86.1 to 86.3 at 2626 to 2627. This is clearly new matter in reply. It relates to the challenge to the city's decision, but given the fact that the applicant seems to have lost any conviction as far as that's concerned, it seems to us that absent any challenge, the matter can remain. I would nonetheless make the point that it is clearly material that is introduced in reply, not raised in the founding affidavit. The founding affidavit in this score, or this connection, contained a bold allegation that there'd been departure from certain policy guidelines, quite impossible to answer in the reply, in the answer. When we pointed that out in answer, that this was typical of the kind of material we were called upon to deal with, these bold, unsubstantiated, broad allegations, well, all the evidence comes pouring out in the reply. It should have been in the founding papers. The exact same point holds for paragraphs 86.4 to 90 at page 2627. This is the biodiversity question. Again, there was just the most abbreviated reference in the founding papers at page 97, paragraph 1937, an absolutely unspecifically, we would say, meaningless reference to biodiversity. And now, in reply, some attempt is made to give some coherence to the case. Again, this is material that must come in founding papers if this matter is to be presented properly. Paragraph 94, it seems on reflection that is, there's no real prejudice there, and given the turn that this matter has taken, it seems to me that it, in any event, is entirely irrelevant and overtaken by events. Paragraph 99 at 2634, again, at 2634, yes, this is where the city's EMD commented on a height issue, and again, another example where it was dealt with in answering papers in a very confined, opaque way, perfunctory allegation, and all the evidence in the form of the alleged comments or view of the city's EMD on this issue is now for the first time presented as the basis upon which this attack is to be relied on. Paragraphs 130 to 132 at 2645 to 2647, we're not persisting with that in the context of relevance and significance. Equally, paragraphs 134.1 to 134.3 at 2648, that seems to have been overtaken. Paragraphs 136 to 137 at 2649. Turning to the allegations in the expert or the replying affidavit of Ms. O'Donoghue, paragraph 17. That affidavit is in volume 8 at page 2983. It appears on the face of it to be a fairly gratuitous attack on the ethics and or the professional ethics of Dr. Townsend. We say that that kind of barb at a fellow professional needs to come out. And finally, in relation to, if you just bear with me, affidavit of Ms. Prince Solani, the paragraphs that we refer to are all paragraphs which go to undermine Mr. Aronser, paragraph 7. The section there attacking his expertise as intangible heritage expert, paragraphs 11 to 45 and 47 to 51 and 53 all go to directly and indirectly an attack on Mr. Aronser, the AFMAS River Club First Nations report, his methodology, his expertise, the nature, I think, of consultation undertaken. All of that material was available to Ms. Prince Solani at the time of the founding papers. The attack on Mr. Aronser and the AFMAS report and the whole ground of review that this was not just a strong recommendation but a 38.3 requirement is raised for the first time in replying papers, and it's based inter alia on this new material. Grounds we submit the strikeout should to that extent be successful. We submit that for the rest, the application should be dismissed. We say it should be dismissed with costs, including the costs of two counsel. We say that in the particular circumstance of this matter, the normal rule in a decision such as EMS Belting, such as Lloyd versus Lloyd, that's a full court decision, 1993. I'll get the court the reference to that. EMS Belting versus Lloyd. In applications for interim relief, the normal order as to costs is if an applicant is successful and obtains interim relief, generally costs should stand over. If the applicant were to be successful and obtain interim interdictory relief, we say the EMS Belting principle should apply. But equally, in circumstances where the applicant is unsuccessful in obtaining interim interdictory relief, the normal order in those circumstances we would submit is that costs should follow the result. We submit that there is no reason in the circumstances of this matter why Section 32(2) of NEMA should come to the assistance of the applicants in circumstances where they're not seeking final relief. They're seeking interim interdictory relief in circumstances where the application itself was misconceived. The appropriate remedy would have been to apply for an urgent review, and the manner and circumstances in which this litigation has been conducted are such that in those circumstances, at the interim interdict stage, the normal rule regarding an unsuccessful applicant for interim interdictory relief, namely that it should be liable for the costs of the unsuccessful application, should find favor with the court, and we would ask for an order on that basis. If I could just, yes, the EMS Belting Co. versus Lloyd, 1983, 1 SA 641E. Those are our submissions.